Okay.
Welcome, everyone. We're delighted that you could join us today to talk about the Supreme Court's Title VII ruling in Bostock versus Clayton County that was issued a few weeks ago. My name is Carlos Ball, and I am a professor at Rutgers Law School. This webinar is sponsored by the law school and by the Rutgers Law Center for Gender, Sexuality, Law, and Policy. Other sponsors are the American Constitution Society, the Rutgers LGBTQ Caucus, the Rutgers Outlaws, and the Rutgers National Lawyers Guild. I'm going to start by very briefly introducing our four panelists. I will then provide a very brief summary of the Bostock ruling. I will then ask our panelists a series of questions. And then after about an hour or so, we will welcome questions from the audience. If you have any questions, please write them down at any time using the Q&A feature the Zoom provides. I will keep track of your questions and ask as many of them as I can of our panelists later in the program. We have an incredible group of experts with us today to talk about Bostock. Going in alphabetical order, Katie Eyer is professor of law at Rutgers and a nationally recognized scholar in anti-discrimination law, both statutory and constitutional. She wrote an amicus brief filed with the Supreme Court in Bostock. She was also a plaintiff side anti-discrimination litigator before joining academia. David Lopez is co-dean of the Rutgers Law School, and he was general counsel of the EOC at the time that agency filed one of the Bostock cases. To put it simply, there are few people in the country who know more about employment anti-discrimination law than David does. Greg Nevins is senior counsel and director of the Employment Fairness Project at Lambda Legal. Greg argued several of the Federal Court of Appeals cases that paved the way for the historic Bostock Supreme Court ruling. And Ezra Young is a path-breaking civil rights attorney who for several years now has been engaged in cutting-edge litigation on behalf of transgender plaintiffs across several different areas of the law, including employment law and health law. So those are our speakers, very briefly introduced. Now let me very briefly introduce you to what the Supreme Court did in Bostock. The court consolidated three different Title VII cases. 2 lawsuits involving gay plaintiffs, and 1 lawsuit brought by the EOC on behalf of a transgender woman. The employers in all 3 cases fired the plaintiffs. For purposes of the litigation, the defendants conceded that they had terminated the employees because of their sexual orientation or their gender identity. But the employers claimed that Title VII, as a matter of law, does not prohibit discrimination on either of those grounds. So the legal question that the court confronted in Bostock was whether or not discrimination on the basis of sexual orientation and gender identity constitutes discrimination because of sex within the meaning of Title VII. Until just a few years ago, the courts had uniformly answered that question in the negative. Among other things, the courts reasoned, number 1, the sexual orientation and gender identity are not explicitly mentioned in the statute. They're not explicit protected classes, and therefore they're not protected. Number 2, courts emphasized the fact that Congress had many times taken up the question of whether Title VII should be amended to add those protected categories, but Congress repeatedly failed to enact those amendments. However, the Bostock court, in an opinion written by Justice Gorsuch, concluded essentially that as a logical and linguistic matter, it is impossible to discriminate on the basis of sexual orientation or gender identity without discriminating on the basis of sex. Gorsuch explained, for example, that when an employer fires a male employee because he's attracted to men, but retains a female employee who's also attracted to men, that is by definition sex discrimination. Both employees are similarly situated because they're both attracted to men, but only the male employee is fired. Ergo, Gorsuch argues, but for the employee's sex, no discrimination would have taken place. For Gorsuch, the logical meaning of the words, quote, because of sex is dispositive. the fact that no one in Congress in 1964 was thinking about prohibiting discrimination against LGBTQ people is irrelevant. It is the meaning of the language that Congress used, rather than Congress's purpose or intent, that matters when the language in question is ambiguous. Now, there were two impassioned dissents in Bostock, one by Justice Alito and the other by Justice Kavanaugh. Interestingly, they also claimed to apply a textualist approach to the statute, but for them, the ordinary meaning, as opposed to what they call the literal meaning of the phrase, discrimination because of sex, is completely different from the ordinary meaning of discrimination because of sexual orientation or gender identity. For example, no one would expect that the plaintiffs in the Bostock cases, after they were fired, the dissenters reasoned, they would have gone home and told their loved ones, oh, I was fired today on the basis of sex. Instead, they likely went home and told their loved ones, I was fired today because I'm gay, or I was fired today because I am transgender. So for Alito and Kavanaugh, sex discrimination is an apple, if you will, and discrimination on the basis of sexual orientation and gender identity is an orange. So we have a lot to talk about today regarding a ruling by the Supreme Court that many commentators did not expect. Fortunately, we have an amazing group of experts who are as well positioned as anyone to help us understand both why the court did what it did in Bostock and what the case means for LGBTQ people and anti-discrimination law going forward. So David, I'm going to start with you. Can you tell us about the EEOC's position on the issues in Bostock and how those positions changed through the years and why?
Yes, no, I'd be happy to. Before I jump into a discussion about the EEOC's role in addressing these issues during the Obama administration, first I want to give a shout out to you, Carlos, because you are one of the best known scholars on the LGBTQ rights revolution. I know that your recent book, Queering of America, The Queering of Corporate America, How Big Business Went from LGBT Adversary to Ally, really touches upon a lot of the same things in terms of the change in the reasons that public attitudes change in this space. The other thing I want to do to set the table is to really emphasize that this result was not inevitable. And as Professor Ball mentioned, for many after the arguments, it was not expected. And I think it's important to highlight that because what it does is, for all of the law students and lawyers out there is it really, I think, highlights the importance of the outstanding lawyering that went into developing these arguments and presenting the issues, both in the courts, but I think also broadly in society as well. The morning the decision came out, I think that many of us would get on SCOTUS blog and ask, is today the day? And wait for the arguments. And I know that the morning the decision came out, I texted Greg about 9:45. I'm like, is this the day? He goes, I don't know. And I'm like, we're going to win. He goes, we're going to win. And I think that Greg and I tended to be pretty bullish, I think, from the beginning. I think because I think we had both devoted so much time to this cause that if we wanted, we were willing to go down with the ship if we didn't win. But I think that when you talk about the lawyering in the case, I think it's important to acknowledge that these arguments were raised right after the passage of the Civil Rights Act. And this is something that Justice Gorsuch mentioned by many, and they were raised unsuccessfully. And that doesn't mean that the arguments were bad. That doesn't mean the attorneys were bad. Many of them were outstanding, very well-known attorneys. The time may not have been right. But one of the things that I think was very pivotal in terms of this historic victory is that the Equal Employment Opportunity Commission, the agency charged with enforcing the anti-discrimination laws, the federal anti-discrimination laws, took a very proactive and very aggressive position that both gender identity and sexual orientation were prohibited by Title VII, by the prohibitions against sex discrimination. And the way the agency did this was very interesting. And I will say that at the agency, there's a real great sense of community surrounding this issue, and a great sense of a shared ownership, because people were working on this issue from all angles, including many unexpected angles. In fact, the first sparks of this issue came from a couple of unexpected sources, not the political appointees, but some of the career civil servants adjudicating federal sector cases, who started to look at the whole issue of discrimination based on gender identity and started to hand down some pretty expansive decisions on gender stereotyping in that space. And then also, I think within the Office of General Counsel, when I started as GC, I had a special assistant who was a trial attorney, a brilliant trial attorney out of Chicago. And he asked me, he goes, I want to go to Lavender Law in Miami. And I'm like, sure. I'm like, maybe you can do a presentation on the EOC's work. And he said, the EOC doesn't have anything to talk about in this space. This was really at the beginning of my tenure at the EOC in 2010. And what happened after that, I think, really made history. He came back and he filed an amicus brief. He prepared an amicus brief in a district court case where the agency for the first time took the position that the prohibition against sex discrimination in Title VII covered gender discrimination, covered gender identity. And that became the springboard for the commission to issue two major policy decisions. The first was Macy v. Holder, which basically reaffirmed that Title VII prohibits discrimination based on gender identity. And then Baldwin v. Fox in 2015, which addressed the whole issue of discrimination based on sexual orientation. And I think the broad thinking at the agency, and I think, and you know, Katie and Greg can jump in on this, and Ezra, but I think in the community as well, is that there had been some good district court decisions on gender identity and some okay appellate court decisions, but in the context of sexual orientation, the appellate court decisions were almost uniformly bad. So I think the strategy was to address gender identity first as a building block to address sexual orientation. So there are two ways that the EOC impacts the law. One is through policy and the other is through litigation. And the two are usually in sync, should always be in sync. So once Macy came down, we had already started to look at our inventory to look for cases that we would use to develop the law and hopefully go to the Supreme Court. And there were only two times, I think, at the agency where we were looking for cases to go to the Supreme Court. And this was one of the times. And so we decided on two cases, and we went through the whole inventory across the country. There was a case in Florida, and there was the Harris Funeral Homes case in Michigan. And both were good cases because both isolated the whole issue of causation. And I personally like the Florida case a little bit better because they were represented by a very big law firm. The partner at that firm had told me at some bar event, we're gonna kick your ass and take this to the Supreme Court, and I'm gonna put my kids through college. That case ended up settling a couple months later. The other case I had some concerns about. What I liked about Harris Funeral Homes is that the whole issue of causation was very clear, that it was very clear that Amy Stevens had been fired because of her gender identity. That was an undisputed fact. The concerns about the case dealt with, one, the size of the employer, that it would look like the big EOCs picking on this, you know, small business, and we sometimes would get into trouble on that issue. And also that we were filing in a district in Michigan where there was a judge who really did not like the EOC and had issued some really bad and harsh decisions against the agency. We were worried about getting this judge. Nonetheless, we filed the case and we got the judge. And sure enough, the judge made, you know, really bungled the decision. During the course of the litigation, Harris Funeral Homes changed attorneys and they brought in the Alliance for Defending Freedom, a nationally known organization that addresses what they would say religious freedom issues, but really in the context of limiting, in my view, limiting the rights of the LGBTQ community. So they jumped in, and when they jumped in, we knew that this case was going to go as far as it needed to go. So we lost in the district court, and then we continued to pursue this case through the Sixth Circuit and got an outstanding decision in the Sixth Circuit. In the meantime, we started to file cases in sexual orientation, and we became incredibly aggressive with our amicus program, filing and arguing amicus cases throughout the country, including some of the foundational cases on this path, the Hively versus Ivy Tech case, which was the Seventh Circuit en banc decision, which was the first decision that determined that sexual orientation is covered by Title VII, and the Zarda case, which ended up going up. In Zarda, this was after the election of the current administration, you got to see your taxpayer dollars at work because the EEOC was arguing in favor of broad coverage. In the case, the Department of Justice was arguing against broad coverage. So there was division within the agency, within the government. How does that happen? EEOC is a quasi-independent agency that makes its own determinations about what to do in the appellate courts. And we made a determination different than what happened in the Department of Justice. During this whole period of time, we were doing a lot of what we call internal litigation, trying to move the government's position. The Obama administration took the position pretty quickly that gender identity is a form of sex discrimination. The Obama administration never made that determination with respect to sexual orientation. And I think some people forget that, but they never really wanted to go that far. They really focused, I think, on Price Waterhouse and the whole issue of gender stereotyping. That was a big part of the arguments that people were formulating. And that was a part that was noticeably missing, I think, from Gorsuch's decision. So that's sort of the story of what the EEOC did. During this period of time, the change of policy meant that across the country, we were investigating cases, conciliating cases based on our views that sexual orientation and gender identity were prohibited forms of, were covered by Title VII prohibition against sex discrimination. And then the story stops. I think during this period of time, a couple of other quick points is we worked very closely with the nonprofits, very closely with other attorneys working in this space. I became, very good friends both with Greg and Ezra, who were also working on this issue. I think one thing that's also important to remember is that so much of this litigation was built on a scholarly basis, and that's something I think that Katie will talk about. But I think it's important to remember that this was not an inevitable result. This was a result of human agency. The arc of the universe may bend towards justice, but it often takes a push. It takes lawyers who are going to be excellent lawyers, who are going to understand the zeitgeist, leverage the zeitgeist, and shape public views in a particular space. And I was fortunate to work with some of the greatest lawyers in the country on this.
Great, thank you, David, and we were fortunate to have you in that role. Katie, if I could turn to you, Bostock not only addresses LGBTQ employment rights issues, but it also includes language that is more relevant more generally to anti-discrimination law. What impact do you think Bostock is likely to have outside of the context of LGBTQ rights?
Thanks, Carlos. So obviously, Bostock is a tremendously important decision for LGBTQ rights insofar as it makes clear for the first time that millions of LGBTQ people have clear employment discrimination protections at the federal level. But it's also got some language that is very valuable to the Anti-Discrimination Project more broadly. There are a number of things you could focus on. I want to focus on talking about the ways that the court articulates and elaborates on what I refer to as the but-for principle in ways that are incredibly valuable for any anti-discrimination plaintiff. So as some of the viewers on this call may know, and I'm sure many of the panelists know, the move towards a but-for standard has been a major project of the Supreme Court over the last decade or so. It's been one that has primarily been advanced by the conservative members of the court, sort of at the resistance of progressives and civil rights advocates who have really strongly advocated for a motivating factor standard as well. In Title VII, we have that motivating factor standard codified, so you can use both or either one. But for some statutes today, you can now only use the but-for standard. And again, that's a result that progressives have resisted. But I think Bostock really shows how the but-for standard can be not only achievable, but indeed valuable to anti-discrimination plaintiffs in bringing their claims, and can provide an important point of resistance to some of the other ways that courts have really retrenched on civil rights. So first of all, one of the longstanding sort of progressive complaints about but-for has been to suggest that this is going to mean that courts can demand essentially sole causation, that you have to show that whatever the protected class was, that was the only reason for the employer's actions. Bostock 100% puts that to bed, right? So they say quite clearly in their discussion that when we are talking about the issue of but-for causation, that means that we, quote, change one thing at a time and see if the outcome changes. If it does, we have found a but-for cause. They go on to say, right, that this can be a sweeping standard. Often events have multiple but-for causes. And the reason why this is so important is, of course, because in today's society, and in reality, even historically, right, discrimination almost never happens purely for one reason. Certainly that's true today, right? So if you look at your standard race discrimination case, it often is the case that the employer has acted not only exclusively because, say, the employee was a Black employee, but also because they have done something, say they were late to work a few times. The key point is, however, that if that employee were a white employee, the employer might very well have overlooked those absences and continued to employ them. So race is a but-for cause. It is dispositive. And the Bostock decision makes clear that in those circumstances, the plaintiff is entitled to prevail. And that's really important because that's something that the lower courts have often gotten wrong in these cases, sort of suggesting if the employer's articulated legitimate non-discriminatory reason has any merit, then the plaintiff loses. And Bostock makes clear that that ought not to be true. The court also makes clear that this but-for principle is not that there is an intentionality required as well, but not the type of sort of strong animus that progressives have sometimes worried and courts have sometimes suggested might be required, right? So the court, in fact, treats intentional actions that lead to a but-for result as the intentionality requirement that is required by Title VII. So that's really important because, as we all know, employers don't always think to themselves, I am firing that employee. Again, let's go back to the example of the Black employee who might have been late a few times. The employer can be treating them differently without self-consciously thinking, I'm firing that person because they're a Black employee, right? Because we are also steeped in stereotypes, right? The employer may be noticing those latenesses in a different way and maybe interpreting them differently. And there's language in Bostock that strongly suggests that that's enough, that we don't actually need this sort of self-aware, self-conscious sort of intent. Because of course that was one of the counter arguments in Bostock itself, was that the employer isn't thinking I'm engaging in sex discrimination when it fires somebody because of their sexual orientation or gender identity. And the court says that's not what's required. The Bostock opinion also, I think, really centers but-for as a factual question. I'm going to get into this a little bit more, hopefully, later on in the questions, but One of the things that's been really problematic for all anti-discrimination litigants is the set of hyper-technical requirements that the lower courts have engrafted on this basic question, was their differential treatment. And Bostock, I think, really takes us back to, this is a simple factual inquiry. Would the outcome be different but for protected class status? And that suggests that many more of these cases should go forward to juries. And then finally, I think, a lot of people were a little surprised and some were rather dismayed that the opinion doesn't focus specifically on gender stereotyping as the core rationale. But I think the opinion actually has some excellent language linking gender stereotyping to the but-for principle and recognizing that gender stereotyping is a form of but-for discrimination, right? So in the seminal case of Pricewaterhouse versus Hopkins, if Ann Hopkins had been a man, her employer would not have objected to her not wearing makeup and jewelry and walking in a too macho way, right? And the court recognizes that in Bostock in ways that I think gives gender stereotyping a really strong foundation going forward and puts to bed some of the lower court arguments that it's sort of a free-floating principle that isn't actually attached to the language of Title VII.
Yeah, that's really interesting, Katie, because except for that last point about gender stereotyping that obviously has a big impact on LGBTQ litigants, most of what you said prior to that was not an issue that was part of the LGBTQ agenda. And it's really fascinating to think about how this victory for LGBTQ rights is going to have spillover beneficial effects for plaintiffs, Title VII plaintiffs writ large. And it's easy to miss that, and that's one of the really exciting things about the opinion. So thank you. Greg, maybe we should talk a little bit about the dissents. Did anything surprise you about the reasoning in Justice Alito's and Kavanaugh's dissents?
Well, yes. Actually, everything did. I mean, in a world where you have Katie Eyer, David Lopez, and you're truly submitting separate briefs telling you the correct way to arrive at the result, it's the fact that any of these brilliant 9 justices would actually not see that. It was a little bit surprising. But the one thing I enjoyed the most was the fact that, and there were two arguments that had been around for in the lower courts, but one of them I thought had kind of died, and that was the argument that that really, and I'm talking about sexual orientation discrimination, that wasn't differential treatment because of sex. I mean, as you articulated in the introduction so well, if a man wants to date a man and a woman wants to date a man, you have no problem with one, but you have a problem with the other. That's obviously differential treatment of the men and the women who work for you. And so. So my thought there, and Judge Sykes in the Hively thing, I represented Kim Hively before the Seventh Circuit in Bank, and she actually tried to challenge that notion that it was, but most of the later cases that you didn't see that so much in the Zarda, and I argued the Zarda case before the Second Circuit too. And you didn't see that in the dissent so much, and you didn't see it so much even in Judge Ho's concurrence in the Whitmer case. I mean, and then Judge Kavanaugh says, well, of course it is literally discrimination because of sex, and of course, for non-lawyers, literally means it is. So I mean, so he was pretty much knocking down Alito's argument, and then, but he said, but Kavanaugh's argument was, well, it may be literally that, but that's not the way people in the 1960s when this law was passed they wouldn't have thought of it as covered by a statute that banned discrimination because of sex. And Alito kind of says, well, that's a dumb argument. We've never thought about the labels that the common person would apply to it as being dispositive. So I enjoyed the circular firing squad quite a bit there. But the other argument that I was glad to see didn't get more hold because it was so counter to and this kind of gets back to Katie's point about it felt good to come out of this decision knowing that we not only won but have moved the cause forward for all Title VII plaintiffs, for all employees who experience discrimination. But along the way we were concerned that some of the arguments that led to some of the counter arguments that Department of Justice was making would actually might make things worse for things if we lost. And one of the arguments was they go like, well, surely something more than just treating men and women differently is required under Title VII. And we're like, not really, and not for the most part. And they kept struggling with the way to they kept saying, well, surely that's the case. And they weren't doing a very good job of pointing to anything in the case law that supported them, because there wasn't anything in the case law that supported them. And so you would see Judge Lynch in his dissent in Zarda just sort of say like, well, this surely is supposed to be the case. And then Judge Ho said, well, for 40 years, the courts have said that it's only treating men better than women or women better than men that counts. And he had no cite to that whatsoever, because there was no cite to it. He just made it up out of thin air. And but by the time it got to the Supreme Court, and the very smart lawyers who were on the other side found something that they could use to actually back it up. And what they used was a quote that Justice Ginsburg had used in a case that it didn't remotely matter at all. So it was just sort of pulled out of, it's a lovely quote. It sounds really good, but it's not the law, and it wasn't even important to that case. And it was, the critical issue is whether members of one sex are exposed to disadvantageous terms or conditions of employment to which the other sex are not exposed. And that came up in a case called where it wasn't at all related to the holding. The holding was just that, like, in that case, was just that it doesn't matter how much mental trauma or how much the plaintiff suffered in the case, as long as they were discriminated against, that's all they had to do to be in court. And then, and of course, in the on-call case, it was also used by Justice Scalia. But that's not what the holding of that case was, because that would mean that that discrimination by men, or sexual harassment of men by men, is only actionable if you don't have sexual harassment of women by men. So it was one of those things where you go like, wow, they did a really good job of finding a quote that matched their theory of the case, except that it was this, it was kind of intellectually dishonest, because it didn't state the law at all. And what was wonderful was when the court just completely ignored that, and you don't see that quote anywhere in the opinions, and that was a very pleasant surprise.
Good. Thank you, Greg. Ezra, a few days before Bostock, the Department of Health and Human Services issued a regulation that could have a huge impact on transgender people. Could you talk a little bit about that regulation and how it might be impacted by Bostock?
Sure thing. So the regulation is colloquially referred to, at least among lawyers and academics, as Section 1557. So that's basically one small part of the Affordable Care Act, which was actually passed when I was in law school. So 1557 for the law students and even some of the practitioners here, but mostly law students, if you want to do civil rights work, take legislation, take administrative law, because a lot of these thorny, sexy problems actually come down to these classes and these basic principles. But basically 1557 incorporates many different other federal statutes, status protection. So in particular, it says that it incorporates Title IX of the Education Act that prohibits sex discrimination in education. And it says, whatever that means in Title IX, we want it to mean that in healthcare. Now, that's obviously like a really poorly drafted kind of statute, but that's what we're dealing with here. So this is what HHS was saying, basically. They were saying they cherry-picked a bunch of anti-trans cases specifically and some anti-gay cases from the Title IX context and a handful of similar sorts of cases in the 1557 context, and said that these all mean that we can ostensibly read transgender people as well as LGBTQ people more broadly out of protection. Because though the statute incorporates something that says no one can be discriminated against on the basis of sex, we're basically going to deem LGBTQ people as exceptional legal subjects because here's a handful of cases that say that's the necessary reading. Now, the problem, if you just look at this logically, other than that being a really disgusting way to interpret any sort of civil rights statute, is all of those cases that they cited all say, even the really vehemently anti-trans, anti-gay ones, all say, well, of course, if the Supreme Court tells us otherwise, our analysis goes out the window. Well, guess what Bostock did? 3 days after this rule came out from HHS, Bostock says, no, whatever this sex discrimination stuff means, it definitely means if you're trans, and they actually don't use gender identity. So I'll make that point. We're not using that anymore because Gorsuch didn't. He uses transgender status, so that's now our rule. God only knows why. If you're trans or gay, that's sex discrimination. We can't meaningfully see a distinction. So what does that mean for this HHS bill? Well, as a practical matter, I think it's dead in the water. Now, does that mean that the Trump administration is going to drop the bone? Not necessarily. They're probably going to litigate it. I know, among others, Lambda Legal filed a lawsuit pretty quickly after Bostock came out for good reason, challenging the rule. So probably there's going to be more litigation. Do I think there's going to be any uptake from any of the circuit courts? Probably not, especially as to the trans protections issue. I think we might have sort of oversimplified where things were before Bostock. Though there were some anti-trans cases in the 70s and 80s from the circuit courts in the United States, not one circuit had such a decision after, I think, the early 1980s. All of the circuit courts that heard the issue, even very, very conservative judges who sat on those panels, including then Judge Gorsuch in 2009 sat on one such panel and came out with a trans win in the Title VII case. None of them were going after that. Do I think any of them, even Trump appointees, are going to have any desire to try to challenge Bostock? No, I think Justice Gorsuch's opinion is pretty definitive. It's pretty sensible. And he got Justice Roberts to join it, right? That's a pretty good signal that the court's unwilling to do it and there aren't enough votes to change it. So I guess that's a simple gloss. Does that mean that the fact that the administration took this position isn't going to affect people's practical access to rights? No, unfortunately, in our legal environment, in our cultural environment, large stakeholders with huge amounts of power, like insurance companies, like employers who maybe think that they'll save a buck if they can buy health insurance plans that have transgender exclusions in them, for instance, might take the gamble. They might want to wait this out and see how much they can get away with. I think David could probably testify to it, and Greg too as well. Just as a practical matter, once the EOC, for example, changed its position and started recognizing that LGBT people were protected, not all employers decided to, toe the line. A lot of them continued to fight. They didn't care what position the courts were taking. They didn't care what position the agencies were taking. We might, unfortunately, continue to see that sort of retrenchment.
Okay. Thank you, Ezra. David, let me come back to you. One of the criticisms that Justice Alito makes of the majority opinion is that the court essentially, in Alito's view, was legislating and went around Congress and therefore didn't give Congress the opportunity to address some of the implications of the court's holding. And Gorsuch, in his opinion, states very clearly, nothing that we decide today has anything to do with gender segregated bathrooms or gender segregated sports or the scope of religious exemptions. There's sort of a long list of issues that Gorsuch, I think, takes some pride in saying we're not reaching those issues. This is a narrow opinion. Alito kind of hits him over the head and says, well, but you need to be thinking about the consequences and implications of the ruling. What do you think some of the implications of the ruling are going to be in those other areas?
Well, I mean, I think there's still some, certainly what I would call hot button areas that remain. And I think that I was somewhat surprised by Gorsuch's, I think, very deft ability to focus on the question before the court and not allow himself to be dragged into, I think, other peripheral matters that had been raised, I think, by the government in this case, by the Solicitor General's office and by the companies. I was surprised because he had asked a question about the social upheaval of a decision finding in favor of coverage for gender identity. And I guess my reaction to that was that he was a little bit in a bubble on that particular issue. But it also, to me, indicated that his radar was attentive to, I think, sort of the broader social context of the decision. But his decision, as written, is it's a very elegant decision. It's a very beautiful decision, and it's a decision that that not only focuses on the text of the statute, the textual basis for the decision, but I think also responds to other purported textualists who say that he's doing it wrong, meaning Alito. But I think certainly, I know that a Supreme Court decision came out as we were on this call that may have some implications. And I think that there is this sort of broad, in some respects, probably overhyped conflict between this decision and so-called religious freedom. But I think that that's something that, as I mentioned, organizations such as the Alliance for Defending Freedom, the Trump administration really, takes those views seriously and will continue to press broad religious exclusions to actually not discriminating against the LGBTQ community. And so those are some battles that are going to just have to be fought out. And those are difficult questions. Those will be difficult questions for this court. I don't particularly find them difficult questions. I also think, the framing of this is sort of a framing of the secular world and the non-secular world is complete BS in my view, because I think, we saw with both marriage equality and with this case that there were large numbers of people of faith who supported the non-discriminatory position and have in large number of denominations that practice regularly non-discrimination and tolerance. But the way this has been set up politically and thus analytically is that this is an issue that's going to have to be, I think, fought about in the future. I think the other thing that Justice Alito noted, and I think that that Ezra touched upon it, is that Justice Alito reminded us, thank you, Justice Alito, that there are already over 100 federal statutes that prohibit discrimination because of sex. This includes the Housing Discrimination Act, Title VI, and many, many other statutes. And one of the first things that the Trump administration did is they reversed the Obama administration's position that that gender identity is discrimination based on sex, and have and all of the regulatory agencies conform to that position. So now, it's going to be interesting what's going to happen in the months coming up to the election, whether the government the federal government writ broadly takes a position that they're going to actually view this as a 6-3 decision that reshapes the landscape as to what is discrimination because of sex, or whether they're going to dig in their heels, either for political reasons or for analytical reasons. So more to come. I mean, this is a great historic victory, but I think one of the wonderful things, or one of the, the notable things about the law is that, when you win, you have to remain vigilant, that the wins are not eroded and frittered away. When you lose, you always have another opportunity, either in Congress or in some instances, later on in the courts. So the struggle continues and vigilance is required.
Thank you, David. Thank you to those of you who have written questions in the Q&A feature. I've been keeping tabs on them, and I will get to hopefully all of your questions in another 15 or 20 minutes. So keep the questions coming, and I will get them to the panelists. Katie, let me ask you, you've written about the obstacles that all discrimination plaintiffs face, even when the law includes explicit protections. What concerns might there be in enforcing Bostock, and how might LGBTQ rights litigators go about addressing those concerns?
Thanks, Carlos. So first, I echo what Dean Lopez just said, right, which is remain vigilant. There is much work still to be done. There's a set of issues, enforcement issues coming out of Bostock that I'm quite optimistic about. I think as Dean Lopez just laid out, the question of whether its reasoning should extend to other sex discrimination statutes. That's going to be a statute by statute analysis, but it's hard to imagine, given the language of most of these other statutes, that a court could come out a different way. I'm also quite optimistic on the issue of how this is going to be extended to sex-separated restrooms and dress codes in the Title VII context. Although the court leaves that issue to the side, the statute, if you take a literal textualist reading, it prohibits altering terms and conditions of employment, quote unquote, because of sex. And it is clear for transgender employees that forcing them to use, a non-gender identity conforming restroom or to dress in non-gender identity conforming attire would violate that prohibition. What I'm honestly more worried about is the set of obstacles that, you know, every protected class faces. So I think we're uniquely positioned at this moment in time to see that having a clear anti-discrimination law intended to protect you does not necessarily mean discrimination goes away or that it's easy to enforce it in the courts, right? If we take a look around at the Black Lives Matter movement and you know, all of the ways that race discrimination persists in our society today, right? We've had major, you know, both constitutional and legislative commitments to race equality, and we have not solved the problem. And there are a host of facets of that, right? Some of them are about society and changing society, and that's important work. And that's something that I think we'll have to continue on for the LGBT rights movement. But some of those are also about how the courts handle these claims and their tendency to engraft these sort of technical legal requirements on what should be a simple factual question, right? Would the person have been treated differently? Would the outcome have been different but for protected class status? And as I've already alluded to, Bostock itself has some great language to help address the lower court's tendency to do this, to dismiss, you know, thousands of discrimination cases before they reach trial because the court applies these technical legal rules and takes apart the facts and says there's nothing left to go to trial based on these technical legal rules. So what I would love to see, and I've actually already said this to Greg, is for not only the LGBT rights movement, but for all of the groups that are affected by these rulings, which really have in meaningful ways eviscerated what are supposed to be clear legal protections for a variety of groups, both to get this out there in the public realm, right? I think people are used to watching Supreme Court opinions, but so many people don't know that the reality for anti-discrimination plaintiffs in the lower courts is this grim, that you can have sort of explicitly biased language by the decision maker and the court can still dismiss your case without letting it go to a jury. But then also to have a litigation campaign that would look at trying to get some of these issues up to the Supreme Court, because again, this is primarily a phenomenon of the lower courts and how they address these claims.
Thank you so much, Katie. Greg, let me come back to you. The court obviously gave us the final answer on that $64,000 question of whether sex discrimination includes discrimination on the basis of gender identity and sexual orientation. But now that we have that answer, if you could go back and reopen the debate that we've been having over the last few decades on that question, and if I give you an opportunity now, I'll give you the floor, sort of clarify any of the points that were part of that debate. What would you want to clarify?
Sure, I'd be happy to. I mean, although first I do want to stress that this, you know, the debate is over, and I can't imagine what Dave and Katie are talking about more work to do, because you know the next day after the decision came down, you know, Sarah Weddington, who argued Roe v. Wade, sent me a hammock that read "Mission Accomplished" and said, "Now's the time to rest easy after all the hard work you've done." No, of course that didn't happen, and it wouldn't happen because vigilance. There's much more work to do, and Katie has really said in very compelling terms just how much it's the case that now that LGBT people have their seat at the Title VII table, we now know that they're no longer, they've secretly replaced the fine filet mignon they used to be serving, and now we're getting ramen noodles like all the rest of employment discrimination plaintiffs. So we need to work as a movement to make sure that Title VII provides the fair and non-discriminatory workplace that the people who enacted it envisioned it to be. So, but just to put a couple of points that I think should be for the people who really dived into the opinions and had some thoughts about, well, weren't there a couple of points here that the dissents made that were good and the things that weren't responded to? One of them concerned, perhaps my favorite case of all of them, the very first sex discrimination case to ever hit the Supreme Court, which was Phillips versus Martin Marietta. And I love that case because it's extremely simple. And if you go back and you read it, and then you read the Fifth Circuit case that led up to it, you get a great idea of what was going on back then in the argument. So this is a case where in Martin Marietta, this had a very good reputation for hiring women in very large numbers and everything. But they also had a rule that said if you have preschool age children and you're a woman, you can't work for us. And the Fifth Circuit said, but of course, men who worked for them and had preschool age children could still work for them and could still be hired. And the circuit said, well, it's not the fact, it's not discrimination against, it's not because you're a woman, it's because you're a woman and you have some preschool age children. And so it's those two things. It's not discrimination against women per se. And they said that was okay. And the Supreme Court could not have been more dismissive in smacking that down and saying, you can't have one hiring policy for men and another for women, both who have small children. And so I thought that was all we needed. I mean, after Obergefell, just substitute wife in for small children. You can't have one hiring policy for men and another for women, both who have a wife. And so, and now that's something that would have been seen blasphemous or anomalous or just goofy back in 1971 when the case came down. But after Obergefell, it's a perfect comparison. And but Justice Alito said, well, you know what? The thing about that Phillips versus Marietta thing, only women were hurt by that policy, and so you can't use that as a comparison. And that, which is a good rejoinder to that argument, except that if you change the facts and say, well, what if Martin Marietta had a policy that said if you have children age 0 to 4 and you're a woman, you can't work for us, and if you have children age 13 to 16 and you're a man, you can't work for us. The idea being that children, young kids need their mother, and rebellious, rambunctious teenagers need their dad. So that you could easily envision something like that being the case. And Sam Alito was basically saying, oh, well, that would be perfectly okay. That would the courts wouldn't have any problem with that. And that, of course, is flat wrong. So I mean, that was one of the instances where he gave a superficial response that probably a lot of people said, well, that's a good rejoinder, and it is, but it isn't once you peel the onion back just a layer. So, and the other argument that I feel I just have to defend because so many it's so convincing to so many of the lower court judges, and because the LGBT movement doesn't have the best of how would I say, best of histories and reputations when it comes to the argument, is the interracial relationship analogy, because this is basically that there under Title VII, there have been a whole bunch of cases in which white plaintiffs were all fired once they had once they married someone who's black, or it was known that they were married to someone who's black, and in every one of these cases the plaintiff was white. And so when Justice Alito says, well, the reason why the law weighs in against that is because because that discrimination against people in interracial relationships is the most vile, racist, anti-black discrimination that you can think of. Yes, that would be true, but the language of Title VII says that that you can't fire an individual because of such individual's race. And if you're saying that the anti-black, it has to be anti-black, that's the only kind of discrimination that counts. Well, then a white plaintiff should have lost every single one of those cases. Instead, they won all those cases because, and this gets back to what Katie was saying earlier, the language of the statute just says you can't. It is unlawful to discharge an individual because of such individual's race. There's no extra component. This is another example of the courts laying on extra things that you have to satisfy in order to have a claim that just aren't in the statute. The question is, were you, the white plaintiff, fired because you were white? Yes, and it wasn't because of some animus against white. It was exactly the opposite. But the fact of the matter is, you were doing something that you weren't supposed to because you were white. You were fired because of that, and that's all that's required. And so, if once people understand that argument and appreciate it, they'll realize that that Justice Alito's thing is a superficial and completely incorrect analysis of that particular argument.
That's wonderful, Greg. Thank you so much. I'm going to ask, Ezra, I'm going to ask you one question, and then I am going to go to our Q&A because we have several questions. Unfortunately now, we have so many that we're not going to be able to get all of them in, but I'm going to do my best to try to get as many of them as I can. Now, Ezra, one of the interesting things about, if we're just focusing on Gorsuch's opinion versus Alito's opinion, is that, Gorsuch obviously comes out in favor of LGBTQ rights. But if you're looking for the long history of discrimination against LGBTQ people, you're not going to find that in the majority opinion. Interestingly enough, you find that in Alito's opinion, because of course his argument is that these are apples and oranges. We have this long history, which is very different from discrimination because of sex. So could you talk a little bit about that history? Does it strike you as accurate? Is it problematic, the way in which he deploys the historical arguments?
Sure thing. So as to Gorsuch's history, I would say he sort of takes the position that it doesn't matter, and that he's not sort of fighting the premise that LGBT people have been discriminated against throughout history until quite recently, right? Which I think is a fairly accurate statement in an easy, just rhetorical way. His fight is textualism. As to Alito, he makes an interesting point. I think he starts on page 27 of his very long, too long dissent. And he starts making these sort of claims. It's sort of this call and response between Gorsuch and Alito. So he goes through all this textualist stuff and then he moves on to history. And he says, basically, there's this history, this received history that we all know to be true. And that history is that the fight against sex discrimination has always been very narrow. It has always been about making sure that men who are men and women who are women, who are defined in very idiosyncratic ways, are not discriminated against in basic ways. And then he starts saying, really, really odd claims. Like, so of course, we all know that in 1964, no one in, the general population would think that sex discrimination protections protect trans people, gay people, or anyone else. We all just know this. And he sort of cherry picks at some weird dictionaries to prove the point. He cherry picks this odd New York Times article that claims that like the first, sex change operation happened in 1966 at Johns Hopkins, and so on and so on and so on. So historically, is this accurate? No. Is it problematic? Yes. This is why. Alito sort of passes down his history, this very narrow conception of how LGBT people have lived, contributed, and interacted both in our legal world as well as just society at large. If you read Alito's dissent and you take it all as true, you'll miss some important things, like, the fact that in 1866, a Black trans woman who was open as such testified in front of Congress, first trans person to ever, 1866, about the Memphis riots, about the fact that she was raped during a race and sexual campaign of terror against Black people, right? You're gonna miss that in the 1930s, 40s, 50s, and I actually found an article as far back as the 1910s, local and national newspapers in the United States were reporting on medical advancements in transition surgeries in graphic detail. These are all parts of our history. Now, there are many other things that we can talk about, sort of paint a bigger picture, sort of the lives of LGBT people and the struggles of LGBT people, right? But the whole point here is to say a false history to justify a certain type of animus. And Gorsuch's response isn't at a point like, doesn't. He's not a scholar, he doesn't need to. He's not good on those rabbit holes, that's fair. But also, there's just no there, right? When someone's just making up a history, a concocted view of the world, steeped in bias, and the only reason why you see the world that way is because you have a certain sort of bias. You don't need to engage with that. All you need is a simple rule like the one Justice Gorsuch comes up with. It doesn't matter what people thought in 1964, what people want to think today. It's all about what the law says. And our job is to interpret the law. And he doesn't say it in so many words, but essentially, if your rule for constructing this is only based on your own preferences and your own biases, that's not enough unless that bias is itself in the text. And if it is, we'll have to look at whether that's okay. And I think that's a really great way to respond to and get to this stuff. But I think if nothing else, for students and some of the professors who are not on this panel but engaging with this sort of drives home the import of uplifting these lost histories, so that students actually realize, like, no, transgender people did not just emerge sometime after 1964 conveniently enough. No, gay people didn't not have relationships out in the open before 1964. Like, this is all I think David said before, so I'll use it, BS. It's done rhetorically to make a certain point, to sort of blind us to all of the context surrounding these hot button legal issues and cultural issues.
Okay, well, thank you. I'm going to go ahead and open up the Q&A here, and I'm just going to read out some of these questions. I'm going to open it up. Any panelist who wants to give a crack at answering this should just go ahead. So one question, which is from a former student of mine, and is an excellent question, I think, if I may say so myself. The question says, given that the Bostock case uses specific language about protection for transgender and gay individuals, Where does this leave others on the LGBTQ plus spectrum? Will we need to litigate specific cases for non-binary or intersex individuals? Or do we assume that this decision will cover discrimination against anyone on the spectrum as being on the basis of sex? Does anybody want to give that a try?
I'm happy to. I assume others have stuff to say too. I would suspect that, you know, what we see in courts is responsive to whatever is going on in society, right? And the case was responsive to the very specific plaintiffs who were here, and they were gay and trans. Are we going to see those cases? Well, if employers do shitty things, there will be cases about them, right? Should any of those cases, or is it likely any of those cases will actually go up to the Supreme Court? I think not. If read fairly, Bostock is pretty clear. The court is not going to treat any employee as some sort of weird, exceptional legal subject that for some reason, even though the statute doesn't say that these sets of folks that we don't like aren't covered, they're not covered. Bostock makes that very clear. And I agree with Katie's other point that I think that sort of construction of Title VII is likely to seep into other areas. We might see it, for instance, in the current fights we see over hair discrimination facing Black folks, right? There are a lot of fights about whether discriminating against someone because their hair and employment and a bunch of other contexts constitutes race discrimination. And the argument's essentially what we saw with LGBT people, that, well, the statute doesn't say that that counts, so it doesn't count. This must be different. I think that we're going to get a lot of cases that start saying in the lower courts, and hopefully none of them have to reach the Supreme Court, we're not doing that anymore. We're not going to just call things different because we hate people. That's not the way we do this. We read the statute.
And also, I would just say, because you know the opinions themselves, the opinion itself didn't say much, or didn't barely mention bisexuals, but the question on which cert was granted is, does Section 703A of the Civil Rights Act of 1964 ban discrimination because of sexual orientation? And there was absolutely nothing in the opinion to suggest that its ruling was limited to exclude bisexuals. So you know, I realize that this is for bisexuals. It may have seemed like yet another example of erasure, and where's our story in this? But I think the good news is that everyone should take heart that none of those lines were drawn in the opinion, and there was no scrap being thrown to suggest that bisexuals in any way don't enjoy the full protections under Title VII that the entire LGBT community does. So I think it's a good day for that. And even though it's always disappointing that the erasure of the stories continues, but as far as coverage under the law going forward, I think it's a good day, and that there should be a lot of happiness on that basis.
I mean, I don't think we're going to see a Supreme Court case. You may see some grappling in the lower courts if, as Ezra says, an employer wants to draw the line in the sand on this particular issue. And I think that one of the things that I noticed in this context is that even after Hively, I think that was a case we all expected to go to the Supreme Court, that if an employer can duke it out on the facts instead of on the law, particularly in this space, they'll duke it out on the facts. And that's why I'm not sure if that, I don't think it's likely that legal issue is going to make it up, but I think it's going to be, I think it's still kind of an open question. And I'd be curious as to what the other panelists make of the fact, and not to be a negative Nelly by any stretch of the imagination. This is a great decision, a beautifully written decision. But I think that Justice Gorsuch used gender identity once in the case, and that was quoting something else, and he was very specific in terms of talking about transgender status when he was talking about.
Yeah, and actually we have a couple of questions just exactly on that point that David just raised. So I know Ezra raised this briefly earlier, and it sounds to me like Ezra is ready to start changing the terminology based on that. I'd be very curious, yeah, if other panelists could speak on that question. What's the relevance of transgender status versus gender identity in the way in which Gorsuch seems to have written the opinion?
I would say there's none anymore, and we were so just so everyone gets has the backdrop. When the Alliance Defending Freedom submitted the cert petition in the funeral home case, you know, it was obviously very loaded, the questions presented on their side. And the Supreme Court rewrote those questions, and Linda Greenhouse had a great New York Times column about this, where she was basically saying, pay attention to the way the court redid it because it probably means that that Amy Stevens is going to win because one of the questions was, are transgender employees protected against sex stereotyping discrimination under Title VII? And of course, the answer to that obviously had to be yes, because everyone's protected. And so we felt really good about that. But I will admit, the only, and I was like I was optimistic Ollie throughout the entire process and saying we were going to win across the board and it was going to be, but the only caveat I ever had to my optimism was because the Supreme Court had drawn the line between transgender status and gender and possibly sex stereotyping, that they might say transgender status wasn't covered. But I think Justice Gorsuch realized, like, look, if you're discriminating on transgender status, you are discriminating on the basis of sex, and God forbid we allow any daylight for the wrong interpretation of the decision, and we are just going to shut this down. And that's why he referred to transgender status, and just basically squash that. And so I think that was one of the really, really wonderful things about the opinion too, so that we won't have to be fighting that battle going forward.
Okay, thank you. I know none of the panelists have read this morning's Supreme Court opinion in Our Lady of Guadalupe School ruling, but our audience is clamoring to hear from you all. David spoke about this briefly earlier, but they want some more. And what you all think the impact of what appears to be a fairly expansive understanding of the role of religious exemptions, what the impact will be and how it might limit the beneficial effects of Bostock. And it's a big question, I know.
It's a very big question. Well, one case I hope has resonance down the line is a little opinion that came out just a couple of months ago, right in the middle of the COVID-19 thing, about whether California's restrictions about churches should stand or not. And it was a 5-4 decision, which tells you two things. One, the fact that it seems like there may be four votes on the court to basically take any religious objection to compliance with the law and give it and say that they're excused in the law. And that is rather frightening. But Chief Justice Roberts, in both this opinion and also in the Espinoza versus Montana Department of Revenue case that came out last week, I mean, there are times in the law when there were times in the law, not after Espinoza, where literally was discrimination just because you were a religion. I mean, where states said we're not going to give any money from the state treasury over to any church because it's just too messy, and so that meant that if you had different bidders for, like, say to do a soup kitchen, that a church would be disqualified, and even if they were willing to provide the soup and do everything on the same terms as everyone else. And I think it's a good thing that those laws are gone. I think if you do it fairly and you don't, and you allow religions to compete on an equal basis, if they say we're willing to abide by all the state's rules for how this program should be, I think they should be treated on an equal basis. And the problem with it is when you have someone using their religion as a sword, saying like the person who says, I mean, you can fire. If the company has an anti-harassment policy, they can fire someone on the spot if they want who engages in anti-gay or anti-trans harassment of another person. It shouldn't be the case that someone's religiously motivated harassment stands on any better footing for that purpose. So if you're trying to use your religion as a sword, you shouldn't be able to. But if you're trying to use it as a shield, saying like we should be allowed to provide the services and engage in society on an equal terms with everyone else, I think that's a good thing. So, and it seems like Chief Justice Roberts in the church closing thing was like, hey, these are reasonable regulations for an obviously compelling purpose, and so we're gonna let them stand, and I hope that that's what carries the day going forward.
So I obviously haven't read the decisions today, but I just wanted to note that I do think that the fact that we now have a decision like Bostock and that there have been increasing anti-discrimination protections for LGBT people that make clear that people can't discriminate just based on secular dislike of LGBTQ people, that does place greater pressure on these religious type exemptions, and it creates greater incentives for those who oppose LGBTQ equality to, truthfully or not, frame their objections in those terms. And again, not having read the opinions here today, I can't speak to exactly what they say, but one of the biggest concerns I have is sort of trying to place sensible limits on the ability of the requirement that the courts not interrogate what is a truly genuine religious beliefs. I think the Harris Funeral Homes case in the lower courts actually had a great take on this, which is we can't just say, yes, always we take your word for it. And I think in this era where everything's getting pushed into that space, it's important for courts to have some ability to really take a look at the sincerity of the religious beliefs that lie behind claims of the ability to use religion, as Greg suggests, as a sword in order to facilitate discrimination where the law would otherwise prohibit it.
And this, of course, is a thicket. And I think if you look at what happened in Harris Funeral Homes below, I think, as I mentioned, Harris Funeral Homes retained new counsel in the midst of litigation, and they brought in Alliance for Defending Freedoms, and they asserted a defense under the Religious Freedom Restoration Act, which I think most people agree applies only to government actions that burden private entities or individuals. And the way that they did that factually is they sort of, what you saw is sort of a discovery of a faith-based basis for the discrimination in that case that had not been asserted at any point during the discrimination, had not been asserted by Harris Funeral Homes during the early stages of the litigation. But by the time it gets to the Alliance for Defending Freedom, then you start talking about how the owner has has these deeply held religious beliefs, and this is infringing upon the religious beliefs with respect to biblical understanding of who is a man and who is a woman, and it really had the appearance, certainly to the Sixth Circuit, and they were probably nicer about it than they should have been, but it certainly had the appearance that it was sort of created after the fact. And that is the danger. And in fact, some of these organizations will counsel employers on how to sort of cloak their organization as a religious organization, and cloak, for those who are religious organizations, cloak the work of what I guess until today we would view, the secular employees as ministerial in nature. And so this is a complicated area of the law, and this is one where I suspect, without having read the decision, that there's going to be a lot of additional litigation. But I also, just sort of looking at the summary, it looks like what happened today probably expanded the ministerial exemption, not just with respect to discrimination against based on sexual orientation or gender identity, but discrimination based on everything: sex, race, national origin. That is part of the exemption. So that's. Yeah.
Oh, sorry. I'd like to add to that and build off of it. I think actually a point David made earlier. Part of one of the problems with sort of these issues going up to the court right now is the courts are presented with a really false dichotomy that LGBT people are always opposed to religious people, which is obviously a bunch of BS, right? There are plenty of religious LGBT people. There are plenty of religious people who see supporting LGBT people as part of their faith, because they have a social justice imperative as part of their faith for reasons we need not get into. So it might be an impetus, and this might present an opportunity for litigators, for academics to present a more complex image of what's going on, right? A question that was never really forefronted in Harris was, what was Amy Stevens' faith? Does her gender have anything to do with her faith? Does it have anything to do with her truth? I'm openly Catholic, I'm trans. My faith is integral to my, my life and who I am and how I navigate the world. I am not an outlier. The vast majority of LGBT people in public surveys say they are deeply, deeply religious, right? So part of what we might do and part of what we do to educate courts and educate the public might be uplifting those narratives, pushing back against these false dichotomies that make it seem like there's always this tension between those two groups, instead of it, quite honestly, at least according to public opinion polling, these views actually being quite outlier views, even in religious faith communities. So I think that's, you know, it's an area of opportunity. It's an area to flesh out things. I also haven't read today's decisions, but I highly doubt it foreclosed all protections forever and ever and ever. It might be an invitation for different sorts of arguments to be raised to the court, right? To study Bostock, what worked and what didn't work in Bostock. How did we get the 6 votes that we needed for anything, right? We might be able to put something together in the 3 religious cases that are going up in this next term and find a way to sort of weave those things through.
Yeah. Thank you all very much for such thoughtful answers. We also have a couple of questions in the QA about the relationship between Bostock and equal protection doctrine. And I'm wondering if any of you want to talk about that. What does Bostock tell us anything about the level of scrutiny that sexual orientation and gender identity classifications merit under the Equal Protection Clause? And then somebody also asked specifically about what Bostock means for the military trans challenge, which of course is an equal protection challenge.
Well, I just want to say, for 5 years, it's been a huge mystery to, all sex discrimination nerds, I'll just say, about what exactly Chief Justice Roberts' position was on this issue, because he was the one who so brilliantly and talk about raising people's hopes, at least mine, during the Obergefell oral argument, when he basically said, and I can never remember exactly which names he used, but basically said, if Bob wants to marry Sue and Mary wants to marry Sue and Bob can't and Mary can't, why isn't that just sex discrimination? And then, so I was going like, oh my God, this is awesome. I mean, anyone who has gotten it to that extent, we've got that vote for sure. And instead, it was the only dissent he's ever read from the bench. And so I was trying to like, what is exactly the Chief Justice Roberts' view of sex discrimination? And I think we now have the answer in the form that, because Title VII doesn't allow any excuse for something as blatant sex classification like that, and that's what he signed on to in this opinion, but the Equal Protection Clause does allow for for justifications of sex discrimination. You have to have, and I can't remember what the VMI cases standard is, but it has to be a very compelling reason, a very convincing reason. And apparently, I think the simple answer is that Chief Justice Roberts must have thought that standard was met in the marriage bans, and it does, and there is no standard to meet in Title VII, so that's why he voted and being the incredibly smart guy that he is, and I think that's why he voted one way in one case and one way the other, which is to say, as far as the transgender military exclusion, where Title VII doesn't apply, in every other case where we try to use equal protection, there will be the argument that there's a really, really convincing argument why this discrimination should be allowed, but don't count on it actually prevailing in among right thinking. And I mean, you'll have to come up with a really good reason for the justification, but it's not foreclosed. So Bostock will be a very powerful tool in the equal protection context, but it's not game over. It at least allows for rebuttal that there's a really, really good reason for this. It's just how often is that really going to be met by smart thinking judges?
Yeah, exceedingly persuasive justification, I think, was the way that Justice Ginsburg puts it in VMI. Katie, did you want to add something to that?
I wanted to add, I mean, I do never want to be the naysayer. I do think there is room for, and I think we will see governments arguing that the logic of Bostock does not translate directly to the equal protection context, largely because Bostock is a textualist opinion that interprets the words because of sex, right? And the Equal Protection Clause has no such language, right? I think nevertheless, right, courts often construe the Equal Protection Clause and its disparate treatment protections coextensively with Title VII. There's lots of reasons that you can argue that Bostock leads to the same result, that we have to have heightened scrutiny as sex discrimination in the equal protection context. But I think that's going to be one of those areas that, as we've talked about, we'll see further litigation in on the issue of whether now categorically it is considered sex discrimination, sexual orientation, gender identity is considered sex discrimination, triggering intermediate scrutiny. I'll also say, apart from that, however, that this is another area where I am less of a pessimist than others. I think there are independently excellent arguments that the lower courts have begun to accept about why sexual orientation and gender identity discrimination on their own merits should receive strict scrutiny or intermediate scrutiny. So I think that both of those remain strong arguments, and hopefully we will see increasing numbers of courts adopting them.
Well, thank you so much. We only have a few minutes left. There's one question that I wanted to ask all of you about the reasoning in Gorsuch and what it might mean for civil rights litigation going forward. And that is the textualist component of Bostock. How do you all think the court's textualist reasoning should affect how progressives think about textualism? And since we only have 7 minutes, maybe we should limit it to statutory textualism as opposed to constitutional textualism, but maybe not. I'll leave that up to you. So what does this mean? What does textualism mean for progressives going forward after Bostock?
I'm going to
go ahead, Katie, yeah.
Who know me know I have been tooting the progressive textualism horn for some time now. And I have to say, even just in looking at some of the progressive responses to the Bostock decision, I just sort of get this sense that a number of progressives are still fighting a war that they don't realize is over, right? They're still fighting this war against Justice Scalia to take down the idea that textualism is a legitimate methodology. And the reality is that the Supreme Court, at the Supreme Court level, I get things are different in the lower courts, but at the Supreme Court level, textualism is the ascendant methodology. I happen to actually be a true believer in textualism, right? Not to all the specifics that some of folks like Justice Scalia would interpret it, but that the text of the statute ought to have significant meaning, that it sometimes does give us determinate answers, right? I think that's important. And I think there are very anti-progressive results that can happen from departing from that. And I think once you start looking around and taking the language of statutes and regulations seriously, there actually is lots of work to be done under the textualist banner. I think that there are lots of pro-civil rights, pro-equality outcomes that we can achieve using textualism as a method.
And yeah, I agree with that completely. And I think it kind of echoes in some respects the work that you're doing on federalism. But I think the framing of textualism as a conservative tool, I think for litigators, is something that has been pushed into the past. And one of the things that we talked about earlier in preparation is that there was a textualist revolution at the EOC. If you compare Macy with Baldwin, you actually see the difference, right? And then in 2015, as we had 3 cases in the Supreme Court, and we were complete ardent textualists with all of those cases, and Abercrombie, Mac Mining, and Young. We were pushing the textualist views. And I think for me, my thinking, and I'm really interested in how these ideas are cross-fertilized between practice and academia. But for me, I certainly remember going to a conference at Berkeley where all of the employment civil rights lawyers were bemoaning the fact that these conservative judges were just sort of making shit up. And they were just constructing legal doctrine that had no basis in the statute. Right. And I think for those of us who practice in this field, and Katie talked beautifully about it earlier, you do see what used to be called, when progressives did it, judicial activism on the part of conservative judges. And I think textualism actually provides, I think, a greater degree, a greater check on that type of chicanery than I think progressives have typically allow themselves to concede. So I do think that, as Justice Kagan said, we're all textualists now. I think that certainly in this field with this case, I think it's important. I mean, I teach Griggs versus Duke Power, which was based on the spirit of the law and had no textual foundations whatsoever. It was a 9-0 decision written by, the famous Chief Justice Warren Burger and supported by the Nixon administration, very fundamentally important because I think it moved into that space. But I think notwithstanding cases such as this, I think on balance, at least in this area of the law, where I've devoted my career, I think textualism is the way to go. And I actually think when you look at the text, there's provisions in these statutes that just haven't been interpreted. The courts have not looked at, right, in great degree. Like, what is color discrimination? There's been very few cases on color discrimination. And I think one of the academic projects, I think for many of us and for the lawyers, is what does the Bostock decision mean for race discrimination, prohibitions based on race? And, we were pressing the natural hair catastrophe case at the OC, and we really tried to tie the two arguments together. But I think that, this really, Bostock opens up a lot of, I think, possibilities that we should definitely take advantage of. I know, Greg.
We have 3 minutes left. I don't know if Ezra and/or Greg want to add anything to that.
Yeah, so I'll add something real quick and I'll let Greg close. I think both Katie and David are right that a lot of progressives have just been reflexively anti-textualist, thinking that textualism is the thing that leads us to all these terrible ends. The problem with that sort of thinking is, one, it's just not true, demonstrably. A lot of these cases, and there have been a lot of signs for a long time, just narrowly in the Title VII LGBT context, that diehard textualists were pro-LGBT before even progressive judges were. And they were sending up all the signals and all the flags all along that is where they got there because of textualism, right? So if we're sort of blinded by the power of textualism to speak to those conservatives, we're going to lose cases. There were very specific arguments Gorsuch and others wanted to hear, and they kept sending up all of these signals. We don't want to hear about this dignity stuff. That's Kennedy, not us. We don't want to hear about all of this other stuff. We want to hear what the text says, right? We don't want you to make these weird concessions about stuff that aren't in the text. We want you to tell us what the statute says, right? So if you miss those things as a litigator, even as an academic, you're going to miss where the court's going, right? So the court's not actually always coming up with the right answer. It's coming up with the answer it wants to hear, and the people who are there right now are textualists, right? So that's important. The other thing that I think is important about textualism is it gives LGBT rights advocates and others in minority communities an opportunity to speak to conservatives that are ideologically against us, but because of textualism, are willing to hear us out and willing to be part of this project, right? This decision might be Ginsburg's legacy, but it was written by Gorsuch and Roberts signed his name to it too. That's not nothing, right? If textualism is how we can get there with this particular court in this particular environment, so be it. We're all textualists. That works.
Okay, Greg, you're going to have the last word for us today.
Well, and I think hopefully fittingly, because I want to just give tribute to what Justice Gorsuch said about Title VII itself, because there was that, when he was using it in talking about, like, don't hide elephants into mouse hills or whatever it was. And he goes, Title VII was a momentous piece, one of the greatest pieces of legislation. Everyone knew it at the time. It was huge, and he goes, like, and it was designed to do big things. Everyone knew it was momentous, and it was, it was right in the middle of the Mad Men era, but its reach exceeded its, the grasp of most common people. I mean, this was a momentous thing, and from a textualist standpoint, the one thing in the early days of Title VII that was so frustrating is that so many of the judges were using the fact that it was introduced, that the sex discrimination provision was introduced at the last second and pushed through as a means to constrain the scope of it. In other words, like, oh, we don't want this sex discrimination prohibition to be too big because it was just thrown in at the last minute. That is not the way a textualist views the law. It was introduced, it was passed in the law, and there were very few changes made from the original law. And the original law basically was like, you can't, there are no good reasons to discriminate on the basis of national origin or race. And so when sex was added to it, in the final law, there were like a couple of differences, very minor differences. But basically, Congress said, you know what? We need to get this thing passed now. It was like only 2 days left in their what they thought their timetable was. And they said, you know what, we're gonna just go over that cliff. We are going to prohibit sex discrimination. And if that turns out to be too radical, we can deal with it later. But this is what we're going to do. And Justice Gorsuch really. It's a different view of what happened in 1964. It's the correct view of what happened, and it's a textualist view of what happened. And that is, the Congress basically said, yes, we are just going to prohibit differential treatment of men and women who are doing the same thing. Period. And he embraced that and said, that is what we should be doing. We shouldn't be trying to say, oh, they didn't mean to do this. They didn't mean to go this far. No, that's what they did. That's what the word said. And we're going to give effect to that. And if you have any issue with that, go back across the street to the other end of, and talk to the people under the dome, because they handle that. That's where those arguments belong. So I think it's Katie's progressive view of textualism embodied perfectly.
Thank you, Howard Smith.
Great, thank you all very much. I should say I had very high expectations of this discussion, and you all not only met them, but you exceeded them. So thank you for a wonderful, thoughtful, enlightening discussion. It was great to see you all, and thank you to the audience for joining us. And we'll see you soon again.
Thank you, Carlos.
Bye-bye, everybody.
Thank you.